Great. So a quick agenda for today. This is pretty much on the invite, actually. So I'll start off by outlining some recent ICO enforcement action, which is always interesting because it gives you an idea about what the ICO are really focusing on and also how to protect yourselves from enforcement action. So we'll cover some of the key takeaways there. And then I'll move on to a few pieces of recent ICO guidance. Now, there's been a lot recently, so I've just picked a few things that particularly interest me, if I'm honest. But if there are any other pieces of ICO guidance that you'd be interested in discussing, potentially at our roundtable event that Nick mentioned, do let us know. And then I'll finish off with just something on the latest on international transfers, and then we can move into a quick Q&A before we round up. Okay, so I'm going to start with talking about some marketing enforcement action. So for those of you who are familiar with the Information Commissioner's Office, they're often referred to as the Information Law or the Data Protection Regulator, which means they regulate UK GDPR, Data Protection Act, Freedom of Information. They also regulate the Privacy and Electronic Communication Regulations, a bit of a mouthful. So we call them PECR for short, PECR. And there's been quite a lot of enforcement action around PECR recently. And some of these I think was really interesting to kind of see how the ICO are tackling PECR enforcement action. So I'll start off by going through what we call, what I'm calling the temp cover fine. So temp cover were the company that were issued with a monetary penalty notice, which is a fine essentially by the ICO. Now, this is quite an interesting decision because it relates to something called the soft opt-in under PECR. Now, there are certain rules around sending electronic marketing. So, for example, there's a particular regulation around sending direct marketing by email and text message. Essentially, before sending direct marketing by email or text message, if it's going to an individual, so business to business marketing is different, but if it's going to an individual, you need to have either that individual's consent to do so or rely on something called the soft opt-in exemption. And there was an interesting discussion around this in the temp cover monetary penalty notice. Essentially, the soft opt-in applies where you obtain someone's contact details during a sale or negotiations for a sale. And as long as you've given the individual the opportunity to opt out at the time you got their contact details, then you can send them marketing for similar goods and services without getting their kind of GDPR standard opt-in consent. But what the ICO made very clear in this enforcement action is that the opportunity to opt out needs to be very clear and quite prominent, because what temp cover were doing is they were putting something in their terms and conditions that people had to sign up to. It was mandatory to sign up to them before proceeding. And the ICO held that wasn't enough for the soft opt-in to apply. Now, a lot of businesses rely on the soft opt-in, and you as kind of individual consumers will have come across a soft opt-in, I'm sure, because whenever you do online shopping these days, if you kind of register for an account with an online clothes provider or whoever, and there's normally a box that you can tick to opt out of communications when you fill in the form. So it's something that's widely used, widely relied on. I think this fine that temp cover were given is really just a reminder to make sure that if your company or your organization is relying on soft opt-in, then do make sure that you're properly complying with it. The next fine I wanted to mention was given to Royal Mail. Now, this was a kind of, in some ways, it's a similar kind of area in the sense that it was still about this obligation to get consent or rely on soft opt-in around sending direct marketing messages, but it was quite a different case in the sense that Royal Mail fell foul of this through pure human error. They weren't kind of, trying it on. They weren't trying to get away with see what they could get away with. It was really human error. They knew what the law was and they were trying to comply with it, but as these things happen, unfortunately, about 200,000 people got sent some direct marketing about some new stamps that they kind of said that they didn't want to receive. And again, it was human error rather than Royal Mail doing this intentionally. And Royal Mail actually reported themselves to the Information Commissioner's Office over this one, even though they weren't obliged to do so because it's not a data breach. So what was really interesting to me over this enforcement action is even though Royal Mail human error, and they essentially spoke to the ICO themselves about it, because a few complaints were received about it, the ICO seems to have taken enforcement action over it. Now, we'll come back to human error and how human error isn't really a get out of jail free card these days when I talk about some other enforcement action later on. But just to say that, it's not enough these days just to say, okay, when these things happen, you are expected to have procedures in place to prevent things from going wrong. And then just the last point on direct marketing and marketing enforcement action is that last week, the ICO published some enforcement action it was taking against a variety or a handful of companies who had been, to use the ICO's words, doing some quite predatory live calls to people. Now, the rules around live calls are different. They're around emails and text messages, but people do have the right to sign up to something called the telephone preference service to say they actually don't want to receive kind of live calls trying to sell them things. So the ICO has taken some quite vigorous, I would say, enforcement action against a handful of companies who were in particular targeting kind of vulnerable people. Now, this isn't something that particularly applies to your organizations, I'm sure, but just to flag that the ICO do very much take enforcement action over these types of breaches. It is something that they're very kind of passionate about. Interestingly, at the moment, the enforcement action the ICO can take over direct marketing, the fines they can issue are actually, they're limited to £500,000 rather than the GDPR really high level of fines. But that is something the government are thinking of changing and reforming. So it could be that fines for these types of things actually become even larger in the future. Okay, so the Cabinet Office. You might remember that back in December 2019, the Cabinet Office accidentally posted a list on its website of everyone that had been given a New Year's honour. But unfortunately, this list also contained postal addresses of some of the recipients of the honours. And actually, this led to the police getting involved at one point over some personal safety issues about these people's address going actually on the public web. Really interesting case around what the key takeaways are here, because even though it's quite a specific set of facts that it's only something that would ever apply to the Cabinet Office because they're responsible for kind of honours and those types of things, there are definitely takeaways for all types of organisations here. The first thing I wanted to cover off is sign-off processes for publications. So the breach could have been prevented had there been better sign-off procedures for publishing things online. That extra step wasn't in place that would have prevented this from happening. The other thing that very much is flagged in the monetary penalty notice by the ICO is the lack of staff training at the Cabinet Office as well. And staff training is something that those of you who have heard me speak before will know that I'm really quite passionate about, because a lot of breaches could be prevented by either more prevalent staff training or better staff training. So this was something that, again, was picked up by the ICO, that the Cabinet Office couldn't kind of say that all of their staff members had definitely received data protection training and that kind of thing. The ICO are now quite clear that staff members should have training before accessing personal data. So have a think about how your new starters are going to have their data protection training before actually starting to handle personal data in the first place. And then the third point to flag here is testing of new software. The testing of basically this breach, to summarize, kind of happened because there hadn't been sufficient testing of some new software that was being implemented. So do have a think about what you can implement at your organization around new software. I know some organizations do kind of pilots with like a small group of staff who can feed back on any issues that they're finding with new software, that kind of thing. Obviously document any kind of testing you're doing around new software for your accountability, so your demonstration of compliance, which is a key data protection requirement. And then lastly on this one, culture. So in my view, culture is very much linked to training and staff awareness. But there was an independent review actually took place over this particular incident. The Cabinet Office, I think, requested an independent review. And one of the things that the ICO actually put a quote from the independent review in their monetary penalty notice. And this really rang true with me. So I'm going to kind of quote from this independent review. So I'm quoting now. So the independent review found that breaches such as the one impacting the New Year's Honours recipients in December 2019 are too easily assigned to human error, where a greater consistency of process, controls and culture across the Cabinet Office could have reduced the risk systematically. So that's going back to the point I was mentioning around the Royal Mail one, that it's not enough these days just to say, you know, these things happen, it was human error. You are expected under the GDPR to take these appropriate measures to comply with data protection law. So yeah, I just thought it was really interesting, and just goes to the importance of creating this culture at your organization around data protection. Okay, so this was to do with bulk emails. So, you know, when you send emails to loads of people, it might be because they've signed up to a newsletter, or you need to send out something to the general public, because warning them about something, that kind of thing. You're sending out an email to loads and loads of people, so a bulk email, as I would call it. This is a really common reason for data breaches in my experience. I think it's possibly the top reason for data breaches, actually. So a charity in Scotland, HIV Scotland, were actually fined over this type of breach, which is quite unusual if you think about the number of this type of breach that happens, because essentially what happened is all of the email addresses were visible when they shouldn't have been. And I think the reason for the ICO fine on this case is the sensitivity. Because it's an HIV charity, you could make inferences that some of the people signing up to the newsletter potentially were either had HIV themselves, or were relatives of people, friends of people that did. So it was very sensitive data, even though it was simply their email addresses that were compromised. So the key takeaways here is that one of the points the ICO makes is that relying on staff to remember to use blind copy probably isn't good enough. That actually, because that's so prone to human error, you should have these processes and procedures in place to be able to do things more securely. Now, I know that there is software available, all sorts of software available, that can send out bulk emails without staff members having to remember to use blind copy. So if you don't have that in place at the moment, it is something that it's worth thinking about investing in, because of the serious consequences in some cases where, you know, something so easily done as putting the recipients in the CC rather than BCC field. And again, it's so common, but obviously can, in certain situations, as this shows, have quite serious consequences. So again, the ICO in their monetary penalty notice flags a few other points as well. And again, it's things like staff training and policies that in this particular case, when they were investigating this breach, they did look at what procedures and policies were in place already by the charity around this, and also around data protection and slightly more generally as well. And they found there wasn't actually enough in place in practice to give staff the guidance they needed on data protection. So do remember that part of your GDPR requirements is to have staff training, staff guidance, because you're only as strong as your weakest link, as it were. So it only takes one staff member to make a mistake for something to go wrong. So really do just emphasizing that these policies as well need to be practical. I see a lot of data protection policies come across my desk for a review, and often they perfectly explain what the law is, but they're more like an academic essay than they are proper guidance. You know, remember, people are busy people, and as much as we all love data protection, not everybody finds it as fascinating as we do. So do try and make any kind of guidance and training at your organization as practical as possible, as snappy as possible as well. You know, don't make it too long, get to the point, and make it really specific as well to your organization. So there will be particular things that is a data protection risk for you that isn't for another organization, and that really should be reflected in the policies and procedures that you give to staff members. Okay, ransomware. So I'm going to spend a little bit of time on ransomware because it really is a high risk topic at the moment. A couple of weeks ago, the ICO published their fine to Tucker's Solicitors LLP, who were fined over a ransomware attack that took place a couple of years ago. As I said, ransomware really, it's just so high risk at the moment. And it's one of those things that we all need to have a think about, in terms of, you almost need to anticipate that you will be the victim, or you will be the potential victim of a ransomware attack. So some of the key takeaways from the Tucker's enforcement action, or monetary penalty notice, I should say, was the importance of having multi-factor authentication, which essentially is, to paraphrase, I'm going to oversimplify it slightly here, but it's basically, rather than just having one set of login details, you have multiple things that need to be put together for someone to get access to a system. So most organizations have it these days. So normally, so to give you an example, so often you might need to put in your password, But then you might also need to generate a random code using an app on your iPhone, for example, or your smartphone, and put that in as well. So it's that extra layer of security. And that was one of the areas where the ICO found that attackers had fallen down, that they didn't have this multi-factor authentication as widespread across their systems as they should have done. And the ICO really do recommend multi-factor authentication around any kind of online access to things as well, because that's a particular vulnerability often. Patching, for those of you with a bit of an IT bent will know, patching is really just updating your systems to make sure that any vulnerabilities are patched, essentially. And again, attackers fell down on this because there was a particular vulnerability in their systems which was relatively high risk and which they hadn't patched, they hadn't updated to the latest level of security for that particular system. So make sure you've got technical measures in place to make sure that your IT team is patching things as necessary. And it sounds so basic, doesn't it? But it's these essential things that actually are so important in protecting you from a ransomware attack. And then the last thing I want to mention is encryption on this one. So encryption is actually specifically mentioned in Article 32 of the UK GDPR. So Article 32, just for a bit of a refresher, is the kind of main security requirement provision in the UK GDPR. And it requires you to have both technical and organizational measures in place to keep personal data secure. So technical measures are the things I've been talking about recently. So multi-factor authentication, patching will be your technical measures, and then organizational measures would be staff policies and staff training. Encryption falls into the technical side of things, and encryption is specifically mentioned as something that's likely to be appropriate as a technical measure. And it's so easy these days to get encryption. And I'm not an IT expert, I'm kind of a data protection lawyer, but my understanding is that encryption really is relatively kind of accessible these days and not too costly. And it really can make the difference between, you know, being the victim of a ransomware attack and not. So really, really important to make sure your systems are properly protected by encryption. So I'll move on now to the section of this talk about ICO guidance. So we can segue quite nicely into the ICO's guidance on ransomware, which was published actually around the same time as they published the monetary penalty notice around the Tucker's ransomware attack. So as I said, ransomware really, it's such a big risk at the moment. And I think most organizations are aware that they have been targeted for ransomware. And I'll discuss in a moment how you can protect your organization from ransomware. So the ICO guidance actually says that the National Cybersecurity Centre consider ransomware to be the biggest cyber threat facing the UK at the moment. The National Cybersecurity Centre, for those of you who aren't familiar with them, are essentially the UK agency responsible for cybersecurity. And I really recommend either you or your IT colleagues or your data protection lead check out the guidance on the National Cybersecurity Centre website. There is an absolute wealth of guidance on there. It's really great for both large organisations and also for individuals as well, kind of learning how you can protect yourself as an individual. There's loads of great stuff on their website. And the ICO guidance on ransomware is full of links to various pieces of National Cybersecurity Centre guidance as well. So like I said, it's just worth making sure that you're at your organisation, your IT team and your data protection leads are very much aware of the latest National Cybersecurity Centre guidance. And often the ICO, when taking enforcement action, will kind of look at the measures you had in place and cross-refer them back to Cybersecurity Centre guidance that was in place at the time and kind of compare and contrast a little bit. So it is definitely something that the ICO expect organisations to be aware of and complying with. In terms of ransomware, there's a few points I want to cover here across kind of all sorts of different things. But I think the first thing I want to talk to you about is what is a data breach? Because sometimes there's a bit of a myth that data breaches are only around loss of confidentiality of personal data. And I think that's probably because that's the main reason for a data breach taking place is loss of confidentiality. But actually, it can also be a data breach if you are subject to ransomware and you lose timely access to personal data. So just to kind of recap what ransomware is, so that makes a bit more sense. So ransomware is where, again, I'm going to oversimplify it slightly for the sake of time, but an attacker or a hacker penetrates your systems and gets inside them and essentially takes some data on your systems and encrypts it and refuses to give you access to that data or give you the data back, give you the encryption key, as it were, unless you pay them a ransom. Normally in Bitcoin, I think, tends to be the kind of currency of choice for cyber criminals. So essentially what happens is you no longer have access to your systems. You may remember a few years ago, the NHS were the victim of the WannaCry ransomware virus. And obviously in an NHS context, this lack of availability of patient data obviously could be absolutely hugely serious. So yes, just to flag that data breaches aren't just about losing something, leaving some papers on the train, or losing a memory stick, that kind of thing. If you lose timely access to personal data, that can always have quite serious implications, even if you're not kind of of the NHS level of sensitivity of data. Obviously, it can have an impact on you reputationally, because you can't service your customers, for example, or you can't service your students if you're a university. So yeah, really important just to be aware that data breaches are wider than just loss of confidentiality. Access permissions. So this is something that's definitely flagged quite strongly in the ICO guidance on ransomware, and kind of feeds back to what I was saying a moment ago around the Tucker's fine, that you should have strong access permissions in place. Multi-factor authentication is one type of access permission, but there are others. So do make sure that your organization has got the access permissions in place that are robust and appropriate for the types of data that you are dealing with. Backups is a really important thing to think about when thinking about how you are protected from ransomware. And I really would recommend looking at the National Cybersecurity Centre guidance on things like backups and the ICO guidance on this, because often having a backup that the attacker hasn't managed to get hold of, and that's the important thing, because attackers will commonly go for the backup too, because that means they're causing maximum distress, and therefore you're more likely to pay the ransom. Now, I should say that the ICO's position, as law enforcement position is too, is that they don't condone paying ransoms. But again, that's something for you to have a look at the ICO guidance on, I think, really. But yeah, just to go back to backups then, so really important to have strong protections in place around the backups you've got in place, because that really is your kind of your defense in some ways. One of your defenses to a ransomware attack not being absolutely catastrophic, having kind of offline backups, for example. And I'm going to talk about staff training again because it's my favorite topic. So how to recognize a phishing email is really important when we're thinking about ransomware, because that's often how the attackers will get hold of your system, get access to your systems, essentially. So they will try and send an email to your staff members, tricking them into giving them their kind of password and ID, that kind of thing. And again, that's why multi-factor authentication is important as well, because it means that you would need more than just a user ID and a password to get access to your system. So staff training on these things is so, so important. And it's not just kind of the usual, as I would call it, phishing emails that everyone's used to, where it's obviously a phishing email. We've all seen those ones, haven't we? We kind of almost roll our eyes and think, oh my God, that's so obviously a phishing email. They're getting increasingly sophisticated, and they're starting to use things like LinkedIn, for example, to learn about you, to learn about your job. Maybe even they'll do a little bit of research on the senior people in your organization to work out who's who. That's often referred to as whaling, where they'll try and impersonate a really senior person. And try and convince maybe a junior staff member into giving away some data, or clicking on a link, for example, as well. It's not just about tricking people into giving data. It could be tricking someone into clicking on an attachment or a link that then downloads malware onto your system. So staff training, really important. And what I would say in respect to this type of staff training is that whilst most organizations would have formal data protection training once a year, this really is the type of thing where regular training can be really, really useful. Just regular staff reminders. It doesn't even have to be like formal training. It could just be, in a team meeting, just spending 2 minutes reminding people just to be on their guard and how to look out for that kind of the spams and the phishing emails of the world. And then I'll stop kind of on this slide just by talking about having the importance of having an incident, well, the ICO call that an incident response plan. Your organization might call it something else. I think we at VWV sometimes call it a data breach procedure. This essentially is a document that you can turn to when the worst happens, because it's so stressful when a data breach happens. So having a document you can turn to that talks you through everything to think about, the thresholds for reporting to the ICO, the thresholds for reporting to individuals, Who is your kind of team on the ground that you'll need to kind of mobilize, your data breach committee, as we sometimes call them, when the worst happens. Just think about having that document in place that you can turn to. And top tip, make sure you store that document offline, because if your systems all go down and you can't access that document because you can't get hold of your systems, it's a document worth having stored offline somewhere. Brilliant. We're going to do a little bit of a poll now. Just very quickly, I'll just give you a minute or two to fill this one out. This is just a kind of the importance of everybody kind of being able to think about phishing emails and recognize phishing emails. So I'll just give you a minute to fill that poll out if you would like to. Obviously, it's optional. Brilliant. Excellent. Yeah, all of the above. Great. Just, it's always worth a reminder, I think, even though, next slide, please, Harriet, even though I think most of us should be aware of these things, it really is just important to be aware of those key flags around urgency, they'll put you in pressure, that type of thing, and making it a motive so people don't think straight, essentially, is what they're trying to do. It's kind of creating a sense of panic, so you're not thinking logically and you're in a rush. Okay, so in terms of ICO guidance, one really interesting development I think recently has been on research provisions. Now, those of you who have been following the government's reforms, or the proposed reforms, I should say, of data protection law, may have come across the fact the government has been a little bit critical of the current research provisions in the Data Protection Act and UK GDPR. Now, I paused for a moment when calling them the research provisions because that's not their official name. That's kind of the catch-all term that we refer to when thinking about these provisions. They are, I have to admit, a little bit confusing. And I think possibly one of the reasons why the ICO has released some draft guidance on them now is, I don't know, but possibly because the government has been a little bit critical of them and how they're not very clear. Now, the ICO guidance on these research provisions, which I'll go through in a moment, just to say the guidance is still in draft form, and the consultation, I think, is still open. I think it's open until the 22nd of April. So if this is something that particularly affects your organisation, so let's say you're in the pharma and life sciences sector, or you're in the university sector, so the research provisions really will be quite key to your organisation, and you want to have your say, you've still got the opportunity to do so on the ICO website. So research provisions, what do they cover? So there's three broad areas, essentially, three areas that they cover. The first one is archiving purposes in the public interest. The second is scientific or historical research. And the third is statistical purposes. Now, none of these are defined in the UK GDPR. There's lots of things in the UK GDPR that aren't defined, which is why we have to turn to ICO guidance and case law. So the ICO guidance is particularly helpful on this particular point around actually working out if what you are doing does potentially fall within the research provisions. Archiving purposes in the public interest is a particularly interesting one because there is actually a recital to the UK GDPR. The recitals, by the way, are not legally binding. They're kind of some text that kind of falls before the articles that are legally binding. It's a very European thing. We don't tend to, well, we don't do it at all in the UK, really. And there is a recital in particular that talks about archiving purposes in the public interest having to be public. So the archive has to be public in order to be able to rely on this. Fortunately, the ICO are taking a more pragmatic view, which they can do because the recitals are not legally binding. And so if you are an organisation that does a lot of archiving for example, historical reasons, so let's say, I'm going to use your university as an example, because I know we've got some universities attending today. So obviously, if you're a university institution, you probably have historical archives because, you know, when your university was founded a few hundred years ago, maybe 1,000 years ago, it's really good for historical reasons to be able to look back, isn't it, and see what happened kind of a few hundred years ago. And obviously, I know organisations do still keep things indefinitely for that reason, that in future decades, maybe hundreds of years from now, historians will want to look back on what we're doing today. And that's probably going to involve personal data. So that's where these archiving purposes and public interest come into quite helpful. Scientific and historical research, my view is that the ICO are taking a really pragmatic approach here, which was hugely welcome to me. And that they're interpreting it, I think, quite broadly, which is really good. Same with statistical purposes as well. Now, obviously, do look at the ICO guidance carefully. They give some indicative factors, which points towards whether you can rely on the research provisions or not, whether you do fall within one of these three things. Now, so why are the research provisions so important? Actually, why do we care about being able to fall within one of these things? So essentially, there are a variety of kind of opt-outs or caveats, maybe even exemptions. I'm not sure really what the word is, around two of the data protection principles in particular. So as you all know, there are 6, arguably 7 data protection principles, depending on who you ask. And these are very much kind of the core of data protection law in the UK. So these 2 principles in particular that are relevant to the research provisions are what we call the kind of storage limitation principle, which is that you can only keep things for as long as you need to for the purposes for which you process the data. Well, actually for research provisions, you are allowed to keep data indefinitely. So that's one kind of caveat, as it were, to that principle. And the other principle is around the fact that it's called the purpose limitation principle, where you collect personal data for a particular reason, and you're not supposed to use it for another reason that would be incompatible with the first reason that you collected it for. Again, there is a carve out, a caveat to this principle around the research provisions, which means that you can change the reason you are using the data for if you are then going to go on to use it for a research purpose, as it were. Now, just a point to flag on that one, in terms of lawful basis, if you are relying on consent, you can't, and you are relying on consent for a particular purpose, you can't then switch and rely on this caveat without then getting fresh consent. But you can if you're relying on a different lawful basis. So just be very careful. It's one of the reasons why consent really is one of, well, probably the most onerous lawful basis to rely on. It gives the data subjects so much more rights around their data. And then just to kind of say very quickly, so obviously research will often involve using special category data, so health data in particular, and also possibly criminal offence data as well. As I'm sure you will know, when you process personal data, you need a lawful basis, as I was just mentioning a moment ago, so consent is one of the 6 lawful bases. But for special category data, you also, in addition to a lawful basis, need a condition. And there is a condition for processing special category and criminal offence data for the research purposes. It doesn't come without its kind of costs, though, because everything I'm saying is subject to appropriate safeguards, which I'll talk about in a moment. And then finally, just to flag various exemptions to data subject rights. So if you receive a subject access request, there is an exemption around the research provisions it's worth having a look at. And the right to obtain the right to be provided with a privacy notice. Again, there is a carve out there. If it would be require disproportionate effort or be impossible to provide someone with a privacy notice, which does come up from time to time in the context of research. There is a specific mention in Article 14 about the fact that if it would be disproportionate effort to give a privacy notice, in particular for reasons of research, that's a reason that you can get away with not providing privacy notices. I should say on that point that the ICO's guidance is that you should carry out a data protection impact assessment if you're not able to give a privacy notice. And then I mentioned that this is all subject to appropriate safeguards because there's no such thing as free lunch. So there are various safeguards, notably data minimization is strongly encouraged. You should have appropriate measures in place to make sure you're not collecting more data than you need. And there's also reference to pseudonymization and anonymization as well. So if you can pseudonymize data, for example, that's very much to be welcomed if you're using the research provisions. And you're not allowed to process the data in a way that involves making decisions about individual data subjects, unless there is a carve out for medical research for obvious reasons there. And you also can't process the data in a way that's likely to cause substantial damage or substantial distress to the data subjects either when you're relying on the research provisions. Okay, video surveillance. Okay, so again, I thought this was really interesting ICO guidance because this is something that I think has grown hugely in its prevalence over recent years. So the old ICO guidance on video surveillance was very much focused on CCTV footage, kind of the traditional CCTV footage. The new ICO guidance on this, which is much broader, essentially. It covers things like facial recognition. It covers automatic number plate recognition. It covers drones. What it doesn't cover, and it's important to note, is it doesn't cover covert surveillance. Now, covert surveillance is rarely appropriate, but sometimes it is. The ICO are hoping to produce, my understanding is they're hoping to produce a new version of their employment practices code in due course. They did a call for views on it a few months ago, so hopefully we'll get something this year. And that employment practices code is likely to cover covert surveillance. But for the purposes of today, the video surveillance guidance they've released a couple of months ago doesn't cover covert, it covers covert, covers uncovert surveillance. So that's why transparency is the first thing on the list of things on the slide. So obviously, as you know, absolute, key requirement of data protection law that you are transparent with individuals about how their personal data is being processed. And in the context of video surveillance, this often means signs up. So the ICO say that you should actually put these signs in a place where people can read the sign before they actually enter the area where there's going to be video surveillance, to give them the choice or not about whether they enter the area. So make sure these signs are prominently displayed as well if you're doing CCTV. Most organizations, in my experience, do some CCTV footage, if not a huge amount. Data protection impact assessments is the next thing to mention. So the ICO say that it's likely that you will need to do a DPIA around video surveillance because it's kind of quite privacy intrusive by its nature. So a data protection impact assessment is a legal requirement where you are about to start processing data in a way that's likely to result in high risks to individuals. Now, the ICO are incredibly pro DPIA, to the extent that I think they're probably lowering the threshold slightly in their guidance around when they think it's a legal requirement, just my personal view. But they're incredibly pro DPIA. And this means that it is something that I think the ICO would look at if you receive complaints, for example, about your use of video surveillance. And it is something that I'm aware organisations have received complaints about before because it is so privacy intrusive. So do have a think about doing a DPIA if you haven't already. The one thing I'd flag about DPIAs as well is that they are actually really helpful. It's not just a tick boxing exercise, they really are quite useful. And actually can form part of a project plan, a new project plan sometimes. So it's not all kind of bad news around DPIAs. DPIAs as well, one of the things that I think organisations sometimes can struggle with DPIAs is that staff members don't always realise that they are a requirement and therefore don't know to talk to the data protection officer or the data protection lead before doing something. So I've heard from a number of data protection leads at organisations who say that they're all pro doing DPIAs, but the problem they have is that they're not told about projects until the last minute. So again, comes back to staff training and staff awareness, as everything tends to. Data subject rights as well. So obviously subject access requests are on the absolute increase. I mean, they've just exponentially increased in number, I think, since the GDPR replaced the Data Protection Act 1998. We're seeing loads of subject access requests at the moment. And we also are seeing subject access requests for CCTV footage quite a lot as well. So people very much are aware of their rights here. So do make sure before implementing any video surveillance that you think about how you are, and this is something that would be built into a DPIA. How are you going to make sure you can respond to subject access requests? The right to erasure as well, I think, is particularly relevant. Now, I'm aware that most organisations don't keep CCTV footage, for example, indefinitely or for a very long time. Normally, I think sometimes if you have a recording, it's automatically taped over every 30 days, that kind of thing. So a right to erasure may be less of an issue because you're probably going to delete it yourselves anyway, but obviously people still have the right to do that. If you do receive a subject access request, then ideally you want to kind of pause that deletion so that you're not deleting footage which someone's entitled to receive. It is a bit of a grey area and the ICO are quite pragmatic on that point though. But do have a think about not just how you will extract the footage, the video surveillance footage, to prepare a SAR response, but think about the practicalities of things like pixelating out the footage. Can you do that? Because a lot of organisations that I speak to, they've received the subject access request, and then they don't actually know how they're going to respond to it without actually kind of having to use external expertise to pixelate. So have a think about whether that's something that you can build into your processes around video surveillance. The ICO are incredibly pragmatic actually on subject access requests regarding video surveillance, because they do say that you can invite the individual in to view the footage as an alternative to receiving a copy. So obviously under subject access request, the right is to receive a copy of the personal data. So the ICO say you can invite people in to view it if you think that's more appropriate because it's less privacy intrusive for someone just to see the footage than to receive a copy of it. Because once they receive a copy of it, you've got far less control over what they might do with it. They might put it on social media, for example. However, the ICO do go on to say that if the individual insists on being given a copy, you will have to think about how you are able to provide that, if you are able to provide it. The mixed personal data exemption is obviously hugely relevant here. So that's where you can't give the individual their personal data without also revealing information about others. So that reasonableness test will come in there as well. But pixelation sometimes is quite a pragmatic way of dealing with these types of things. And then just a final point on this slide. So the ICO have clarified that live streaming does count as processing under the UK GDPR. So this is where nothing's being recorded. It's simply you've got a camera, for example, and then it's shown on a monitor, but there's no kind of record kept. The ICO's view is that that does count as processing, so that will still be caught by data protection law. Okay, so I'll just do a final session on international transfers. So international transfers, obviously quite a hot topic over the last few years. The ICO has clarified what counts as an international transfer now, which is great news. So those of you who heard me speak last year, I think it was, time flies, the ICO had a consultation out, I think, when I last spoke around international transfers. One of the questions the ICO were consulting on was this issue around what should count as an international transfer. So specifically, whether it was an international transfer whenever personal data left the UK, or whether it was only a international transfer when data left the UK and then went to a receiver who wasn't caught by the UK GDPR. Because without wishing to get really in the weeds on things and really geek out, there are extraterritorial scope provisions of the UK GDPR, which means that you can be based in the States, for example, the USA, and still be caught by the UK GDPR. So, for example, if you are targeting goods and services at someone in the UK, in certain circumstances, you will be caught by the UK GDPR, even if you're outside the UK. However, we now have clarity from the ICO on this, and I've put a quote actually from the latest ICO guidance on this on the slide for you. So the ICO's view now is that if you are agreeing to send personal data or make it accessible to a receiver located in a country outside the UK, that is enough, even if they are subject to the UK GDPR. That, I'm pretty sure, is following the same line on this particular legal point as the European Union, I think. So I think we're being consistent with the EU there. Just a quick recap on international transfers. So essentially, and forgive me if those of you who are on this webinar might have seen me speak about this before, just a quick recap. Whenever personal data, as I said, leaves the UK, it must retain the same level of protection, as it were, than it has under the UK GDPR, because we live in such an international world where data is flowing about the place all the time, and we, tech companies, for example, are based all over the world. So the idea behind international transfer provisions in the UK GDPR is to give protection to us, essentially, as people who are protected by the UK GDPR when our data goes, for example, to the United States or Australia, that kind of thing. Now, the good news is that many countries are deemed to have adequate data protection law. Now, this, for quite obvious reasons, includes all of the European Economic Area, because they are subject to the EU GDPR, which is basically identical to the UK GDPR. So they have similar protection. And there are a list of about a dozen other countries as well that are considered to have adequate data protection law. So you don't need to worry when you're sending data to those countries. So that list of adequacy decision beneficiaries, I should probably call them, that includes New Zealand, Argentina, Israel, the Channel Islands, the Faroe Islands, the Isle of Man. So a few other countries have got this adequate, Japan as well, have this adequate decision. Notably, the USA do not have an adequate decision at the moment. They used to have something called, there used to be something called the Privacy Shield, the EU-US Privacy Shield, but that was struck down thanks to a privacy campaigner called Max Schrems. And his name will come up in a moment as well. So where you are transferring data to a country that doesn't have an adequacy decision, then you need to put a safeguard in place. The kind of most commonly relied on safeguard are the standard contractual clauses, the EU call them, We are now calling them the international, we're now calling our kind of equivalent of the SCCs, the International Data Transfer Agreement, the IDTA. There are derogations from the obligation to put a safeguard in place. These derogations or exemptions, as some people call them, are quite limited in scope, limited in application, and some of them either as well can't be relied on by public authorities performing their tasks. So it's very important to carefully look at these derogations to see if you can rely on one. They're not really appropriate for routine transfers of data, but they are appropriate for kind of ad hoc things. So for example, if you need to transfer data because, I don't know, someone's abroad and medical information needs to be transferred in an emergency, vital interest, that kind of thing is a derogation, but they're not widespread. So really we're looking at safeguards, and the main safeguard, as I said, is this contractual clauses, as it were, between the exporter and the importer that protect the data. Okay, so like I said, the International Data Transfer Agreement, I'm still getting used to saying it, the IDTA, came into force on Monday, actually. It came into force on the 21st of March. It was before Parliament and they approved it, I think. So it came into force on the 21st of March. Now, this essentially replaces what we call the old EU SECs. Now, the good news is you might be thinking, oh goodness, it was on Monday and I've missed it. But don't worry, there is a considerable grace period for the IDTA. So for existing transfers that are already taking place, you have until the 21st of March, 2024. I know time flies, but it doesn't fly that quickly. So you've got plenty of time to move your existing transfers onto the new agreement. And then for new transfers as well, you still have until September. So you can still keep using the old EU SECs for any new transfers as well. There are certain caveats to that around, I think the ICO say that if it's going to kind of, if the risks change considerably, you can't use them. And then just to say, there is a UK addendum to the new, there is a UK addendum to the new EU SECs. So when I talk about the old EU SECs, they are, I say ancient, they're quite old now. I think they came in 2004, 2010, I think were the relevant dates for those. So because we left the EU before the new EU SECs came in, the applicable ones for the UK are the old EU SECs. It's one of the most complicated areas of law. So these new EU SECs, which are much better than the old ones, you can rely on them to comply with the UK GDPR if you use a UK addendum, which has also been approved by Parliament. So if you do a lot of international transfers with an EU element as well, or an EEA, I should say, European Economic Area element too, sometimes it's easier to use this UK addendum. Now, I mentioned the names Max Schrems a moment ago, so I think most of you will probably know that thanks to a case called Schrems 2, as well as relying on contractual clauses to keep personal data safe, we have to do a transfer risk assessment. Now, I'm not going to go into a huge amount of detail on those today because we are still waiting for the ICO guidance. Next slide, please. So the ICO said at the beginning of February that, as well as the new IDTA, when it published that, it said that some new guidance would be due. It was coming soon, I think were the words you actually used, coming soon. Now that was beginning of February. So when I sent out the invite for this webinar, I thought we might have it by now, but we haven't. So everybody cross your fingers that we have this new ICO guidance and international transfers by the time we do our roundtable event, which I think is on the 5th of May. So it would be a really good discussion topic, I think, for that. So just a flag, keep your eyes peeled for this new ICO guidance because it looks really, well, from what they're saying, it's going to say, this is pretty much a quote from the ICO website. So we are expecting further guidance on transfer risk assessments. And for those of you that are aware of the EU guidance on transfer risk assessments and how onerous that is to comply with, the draft that we saw from the ICO on transfer risk assessments was much more pragmatic. So let's hope that the ICO final version of this guidance remains as pragmatic as the draft version that was subject to consultation. And we'll also be getting hopefully further clarifications on bits and pieces around international transfers guidance too. I think that's it then. So next slide, please. I think we're almost there. Ah, brilliant. There we go. Time to get in touch. Right, Nick, I'll hand back to you if that's okay.
Great. Well, thank you very much, Claire. You can take a well-earned breather just for a moment, though, and just say thank you very much. That's very interesting, very informative, as always. The good news for you, Claire, might be that there is so far only one question, which I'll put to you shortly. The downside to that is it gives me an opportunity to ask some questions that have cropped up. So you might have to deal with those if there aren't further questions from our delegates. The specific question that we have had, I think, is just in relation to when you were talking about international transfers. And the question is it the same transition period for the addendum to the EU SCCs?
Off the top of my head, I think it probably is. But I might get back in touch with the person who's asked that question actually, and I'll just double check that.
Okay, great. Well, thank you very much, Claire. So yes, but let's check that one and we can get back to you. So no other questions come in so far. Do please put them in the Q&A if you do have them. But I just wanted to ask Claire, I was quite interested in the ICO's approach, and I just wondered whether you were sort of seeing any sort of changes in it or anything like that, because to me, the Royal Mail accidentally sending it to 200,000 people and getting fined 20k versus the temp cover sending out 30 million messages and only getting fined 85k seems that I can't quite weigh those up together. What's your sort of view? What's the approach of the ICO at the moment?
Yeah, the ICO, I think it's just the size of Royal Mail. So they will often consider the organisation's resources and ability to pay when fining. So obviously the Royal Mail is an absolutely huge organisation with tons of resources. I'm not aware that obviously under the UK GDPR, they can fine up to a percentage of turnover. I don't think PECA has the same provisions in it, at least for the moment, but I think the ICO do take into account kind of ability to pay, and temp cover I just don't think are as big a company.
Okay, interesting. Thank you very much. We have had another question, and that is, where does cloud storage fall in terms of international transfer? So sort of thinking about Microsoft and the likes of Google here.
Yeah, that would be an international transfer. If you have cloud storage, which is stored in the United States, for example, which is quite a common place to store data, they've got lots of data centers there, that does count as an international transfer.
Great. Thank you very much. Another quite distinct and specific question. Great. I was also interested in video surveillance, and particularly you sort of mentioned the prevalence of that. That came home to me the last month, where I think one of our neighbours had their shed broken into, sent out to the neighbourhood WhatsApp group, has anyone got any video footage or photos or anything like that of the individuals that did it? And the amount of people who have Ring doorbells or things like that. So I just wondered, I mean, obviously you've looked at it from a business perspective, obviously, but from a personal perspective, are there data protection issues there as well? Like if your camera goes onto the road where you might pick up lots of passers-by and things, are there any live issues around that, or is it something just to be cautious of for the moment? It's
really interesting. So there's something in the GDPR commonly called the domestic purposes exemption, which means that if people are processing personal data for household reasons, purely personal household reasons, that the UK GDPR doesn't apply to them. However, there was a case recently somewhere in Oxfordshire, I think, where somebody was using their Ring doorbell. I'm going to get the facts a little bit wrong here, but they basically got into trouble because they were using their Ring doorbell for reasons that weren't entirely above board, I think. So they got into trouble.
Was it one of those terrible neighbour disputes that always
might have been, yeah, something like harassment.
It
was something awful. I remember thinking it's really bad. But so they got into trouble over it. And I'm pretty sure that you need to be careful, essentially. So the law isn't quite as draconian on individuals for understandable reasons as it is on organisations, but it is certainly something to be aware of. And what I will say as well is that everybody is now more aware of their data protection rights. So the likelihood of someone kind of complaining about you to the Information Commissioner is now much higher than it was 2, even 3 years ago. So yeah, definitely something to be careful about. Yeah, Ring doorbells hugely prevalent. I think for the most part, probably not covered. You do have to pay a fee to the ICO of a certain CCTV footage as well. So it's probably worth looking into whether you need to pay a fee to the ICO. I'm pretty sure for purely domestic CCTV, you're okay.
Okay, that's interesting. I will continue to look into potential CCTV systems in that case. We have had another question asking whether we could go over some of the research provision implications again. I'm slightly cautious about that because we've only really got a minute to until the end. What I can say is that I can see that this session is being recorded. So I think our marketing team will be uploading this shortly. So you will be able to revisit it. And I think we will be sending out the slides to everyone that came along. So whoever asked that question, I don't think we can go over it again now, but we will follow up, and you'll get an opportunity to sort of review the slides and see it again. Okay, so one final question then. Can you give your opinion on best practice when a company receives a DSAR and needs to disclose shared data use using WhatsApp and Teams?
Loads of things to think about there. That sounds like quite a complex one. So I advise on SARs all the time. The thing that springs to mind for me around use of WhatsApp and Teams messages is that absolutely during the pandemic, we saw an absolute explosion in people using them. The first thing I'd say, like, my love of staff training, make sure all your staff are aware that if they're using your work systems to, instant message each other, that is potentially disclosable under subject access request. So let's make everyone clear of that. Second thing is have a policy around staff use of those systems, so they're aware of that. In terms of personal devices used for work reasons, so if someone's using a personal WhatsApp chat, but they're using it for work reasons, that can also be caught by subject access request as well. The mixed personal data exemption is likely to be relevant there too, because you're obviously going to have the personal data potentially of the requester, but also the person who sent the message to. So there might be a balancing exercise to do there regarding the, I'm going to assume for the sake of, I don't know if I'm being unfair here, assuming that this message potentially might not have been very nice. So you've got the privacy of the person that sent it to kind of balance up with the right to the individual who's made the SAR to the copy of their data. So loads of things to think about when it comes to ASH requests. So that might be one for our roundtable, Nick. Same with the research provisions, maybe a good topic to talk about at our roundtable.